Hello and welcome to episode 3 of Obiter, the Durham University Pro Bono Society podcast. My name is Jeffrey Paul.
And my name is Stacey Stroud.
Today we have here with us Mr. Roger Masterman. He's an academic expert on UK constitutional law, and his teaching and research focuses on constitutional reform, especially with respect to the Human Rights Act and the doctrine of the separation of powers. He's published several books on these subjects, the most recent being Exploring Constitutional and Administrative Law, which should be out in May this year. If you're a first-year student listening to this, you'll be particularly glad to know it's targeted at you and will hopefully be a little bit less difficult to carry around than your current prescribed text. Thank you so much for being here with us.
Thank you.
Today we're going to talk about the Bill of Rights Commission report, which was released in December, I believe.
That's right.
Yeah. So can we start with a little bit of background on the Bill of Rights Commission? Why was it set up and what were the initial goals?
Well, the Bill of Rights Commission was set up, I think, largely due to political disquiet over the Human Rights Act. Firstly, over its content, and secondly, possibly over the way in which it has been given effect. Now, in terms of the scepticism over its content, I think that there are a couple of issues here relating to the rights that that are currently protected as a result of the Human Rights Act. Firstly, there is the difficult point for some, that is, that the rights given effect under the Human Rights Act have a source that is external to the United Kingdom. They have their source in the European Convention on Human Rights. So there is a difficulty for some that this external body of law, the European Convention itself, and the 50-plus years' worth of jurisprudence coming out of the European Court of Human Rights, there is a difficulty for some that this external source of law is influencing legal developments in the United Kingdom. And I guess the difficulty here is one that you could talk about in terms of parliamentary sovereignty. So you have the idea, the suggestion that legislation coming out of the UK Parliament is sovereign, is the highest source of law recognised domestically. But you have to now temper that idea with the acknowledgement that an external body of law is influencing how legal developments can be shaped at the national level. So there is an issue of legal sovereignty, but then the political dynamic of this is what you might call political sovereignty. There is a sense that politicians in the UK, the people who we elect on our behalf to govern, themselves have ceded a degree of control to this external body. And some of them clearly are not comfortable with this. The strong line of Eurosceptic thinking in British political debates. And so this is another manifestation of that. The second difficulty that flows from this is the sense, rightly or wrongly, that the European Court of Human Rights is overreaching itself, is going beyond the brief that it was originally given. And in many ways this is correct, because the European Convention was a treaty, that's exactly what it is, a treaty that was drawn up, in 1950, 1951. Times have clearly changed since then. The original treaty was meant to be a protection against the excesses of the kind of, fascist regimes that existed pre and during the Second World War. And so it was a response to that. Political climate has completely changed in Western Europe since then. And so the Convention, because it's a living instrument, has been able to, adapt, modify, and change with that changing political environment. And for some in UK politics, this seems to translate as European Court of Human Rights overreach. It's extended its own brief. It's interfering now in areas of domestic law that wouldn't have been countenanced by the drafters of the European Convention, and therefore it's something that we should be kind of slightly wary of. And the third difficulty which then flows from this is that these rights are not perceived as being British rights. They're perceived as being European rights, and certain elements of the press and certain politicians use that fact in order to attempt to portray these rights as being foisted upon us or dictated to us by this supranational body, the European Court of Human Rights. They're the kind of the European difficulties which lie behind the creation of the Bill of Rights Commission. There is also, I think, a little bit of scepticism over the approach of UK courts to the policing of the rights contained in the Human Rights Act. You've seen this, I think, probably most evidently in the ongoing litigation and subsequent legislation on anti-terrorist measures.
Yeah.
You can see it in the debates over whether prisoners should have the right to vote, in the debate that took place in Parliament at the early last year or late the year before, in which Parliament said, a majority of members of the House of Commons said that decisions over questions like this should be made in Parliament. I mean, you also saw it very, very well in the response of certain politicians, notably the Home Secretary and the Prime Minister, to the decision of the Supreme Court in the Sex Offenders Register case, which declared the relevant legislation incompatible with the Convention for the reason that it imposed a sanction for life with no possibility of appeal whatsoever. The Supreme Court in that case said that that was incompatible with the Convention, that there should be a right to appeal against your inclusion on the Sex Offenders Register. The politicians had a complete and utter meltdown in response. So there's scepticism over the court's approach, and then finally, I think there's also scepticism over the idea of rights themselves, because in certain branches of the government, the Conservative branch, there is a suggestion that rights are not self-evident. They should not be available to everybody. They should not be universally applicable, basically. There is a suggestion in government that rights should be contingent on responsible, good behaviour. And for many who support the ideas relating to human rights, this is an incredibly difficult thing to rationalise. The idea of human rights, that they should be inherent in every person, doesn't sit very easily with the idea that good behaviour entitles you to the benefits of legal protection of your rights. I mean, you can see this most clearly, I think, in a debate over prisoner voting, where you have a whole range of politicians saying, well, because these people are in prison, because they've committed a criminal offence, these rights that they may have previously had should be jettisoned. And so you have a degree of scepticism over the idea of rights, or at least the idea of rights without responsibilities.
What is the conclusion then, now that the report is out, or the provisional report is out? Are there any proposals? Are there any solutions?
Well, that's a difficult question to answer, I think, because the report itself was a majority report. So the Human Rights Commission, the Bill of Rights Commission, was not unanimous in its findings. The majority of the Commission found that there was what they called a strong case to consider arguments for a United Kingdom Bill of Rights. Though on this point, even the majority seem a little bit uncertain of themselves, because they added that on balance, there appears to be a strong argument for a United Kingdom Bill of Rights. They don't even seem entirely certain of the fact that there is a strong argument. But that aside, there was a split between the majority and the minority. There was a minority of members, Baroness Kennedy and Philippe Sands, who felt that case for the United Kingdom Bill of Rights had simply not been made out at this point in time. So there was a bare split. But then if you kind of dig a little bit deeper and look beyond that, there are a whole range of kind of differing views that then start to appear. I mean, one difference of opinion between the majority members appears to be whether the new UK Bill of Rights, or any new UK Bill of Rights, should do more or should do less than the Convention currently does at the moment. There seems to be a minority amongst the majority who felt that exiting the Convention system might well be an option for the United Kingdom. In contrast to that, some members of the majority, Lord Leicester included, would, I think, only have gone along that line if they knew that the proposed British Bill of Rights was to be kind of Human Rights Act Plus, was to be a stronger instrument than the Human Rights Act currently is. So it's difficult, given the range of opinions and given the range of kind of appendices to the report, which include a whole range of different viewpoints from the various members of the Commission. It's difficult to discern strong conclusions, other than that they recognise a case for a Bill of Rights exists, or at least the majority of them.
Because there's two volumes. One is the actual report, and then one is the appendices to the report.
Mm-hmm.
So you did mention that we've got the Human Rights Act in force now,
Yes.
but the Bill of Rights, what sort of differences would it actually have from the Human Rights Act if it were to go ahead?
Well, that's actually quite an interesting question, because looking at the Commission's report, it's quite easy to see that some of the mechanisms in the Human Rights Act and some of the mechanisms that the Human Rights Act currently adopts are actually looked upon relatively, favourably by members of the Commission. So I think that there appeared to be a majority viewpoint, or maybe even a unanimous viewpoint, that whatever Bill of Rights might be adopted at some point in the future would contain the core rights that are currently protected under the European Convention on Human Rights and given effect domestically under the Human Rights Act. So I'm talking about the right to life, the prohibition on torture, the right to a fair trial, freedom of expression, the rights that we're all fairly familiar with. There was no great sense that any of these rights should be, excluded. There was also, I think, a degree of support, perhaps, for the idea that a British Bill of Rights, or the mechanisms, for the United Kingdom Bill of Rights, the mechanisms should be, and I quote, broadly similar to those adopted in the Human Rights Act. So there was a degree of support for the notion that whatever instrument might emerge from these debates should have a declaration of incompatibility mechanism, because the majority of the Commission appeared to be relatively satisfied that it struck a balance, or an appropriate balance, between judicial enforcement of legal rights and what was consistently referred to in the report as Parliament's ultimate sovereignty. So there was the idea there that the Declaration of Incompatibility mechanism struck a good balance, I guess, between democratic and judicial protection for human rights. There was some positive comment in the Bill of Rights Commission report on how Section 2 has come to be interpreted by the courts. And Section 2 in the Human Rights Act is the provision which requires that in considering a convention rights case, domestic courts should take into account the jurisprudence of the European Court of Human Rights. There is a degree of feeling, I think, in the Bill of Rights Commission report that the way in which the courts have now come to interpret Section 2, in that it permits a degree of dialogue between domestic courts and the European Court of Human Rights, in that it doesn't necessarily force courts to adhere to the decisions of the European Court. There's a degree of support for this interpretation, I think, of Section 2. It was perhaps less clear whether or not the Commission would replicate Section 3 in any proposed Bill of Rights.
And Section 3 is the...
Section 3 is the provision in the Human Rights Act which requires that courts interpret primary legislation, whenever enacted, in a way which is compatible with the Convention rights, so long as it is possible to do so. And if it's not possible to do so, then the courts are permitted to issue a declaration that legislation is incompatible with the Convention rights.
Yeah.
So this was a slightly more difficult issue. I think there was certainly a body of feeling on the Human Rights Commission that the courts had overreached themselves, the domestic courts this time, had overreached themselves in interpreting and applying Section 3, and that in doing so, the courts had then begun to trespass on the rightful kind of constitutional territory of Parliament, namely legislation. Difficulty here is that the minority pointed out, possibly accurately, and now you can see where my sympathies lie, that the majority didn't actually point to any shortcomings in the Human Rights Act or in its application by the courts. So this is a big difficulty here. But the way in which the Act has been interpreted and applied by the courts wasn't the big bone of contention.
What was the big bone of contention? Why are they so persistent in pursuing a Bill of Rights as opposed to the current Human Rights Act?
Well, I mean, as you'll be aware, there are a whole range of stories. Some of them true-ish, some of them with a grounding in truth at least, others not so true, which have grown up around the Human Rights Act. So we'll all be familiar with the idea that the Human Rights Act only protects terrorists or terrorist suspects, and that the Human Rights Act routinely elevates the rights of minorities, namely people who are suspected of criminal offences, immigrants and the like, above those of the majority law-abiding citizens, people who don't contravene the law in other ways. And again, here you see the problem about this universality debate. Our basic idea that human rights should be available to all is translated in practice into a scepticism over the types of people that human rights are available to, or at least the types of people who become litigants in human rights cases. And there's something rather unfortunate here, because the message clearly hasn't got across, has it? That human rights, in theory at least, should be available to everybody, and then in practice, when we find that immigrants and people suspected of criminal offences and the like are the people who routinely exercise their rights in court, when we find that this happens, then there's a kind of an outcry of some sort. And you see it all the time in press reporting and indeed in political posturing, most recently from Theresa May, over the scope and applicability of Article 8. So here is the difficulty, I think, that there's a difficulty in translating the purpose and the mean and the necessity of the idea of rights into practice in a way which appears to be palatable. Yeah. And again, this is obviously a difficulty, because palatability to the majority should not be a concern of human rights law. If human rights are to be universal, your behaviour, does not need to be deemed to be kind of acceptable to the majority in order for you to benefit from the entitlement of human rights. In fact, the contrary, because terrorist suspects, criminal suspects, immigrants and the like are the types of people who are likely to have their human rights interfered with on a more routine basis than your so-called law-abiding majority.
Well, I was going to say, what do you personally think? But I think your sentiments are very clear. So through your research and through all the work you've done, what do you think needs to change about the present system, apart from the perception that human rights should only apply to a certain type of person? Aside from that sort of social perception, in the mechanism of human rights application in the UK, do you think anything needs to be changed?
That's an interesting. It's an interesting question. I don't want to be portrayed as an apologist for the Human Rights Act or for judicial interpretation and application of it. But I have a concern that there is a kind of a tacit objective in this whole Bill of Rights enterprise that is not immediately apparent from the terms of reference of the Commission, is bubbling under the surface in the differences between the majority and the minority of the Commission's membership, and which basically is the risk that whatever instrument appears out of this whole debate, if any instrument in fact does, will be significantly weaker than the Human Rights Act currently is. So you have in all of these debates that took place prior to the establishment of the Commission, you have the Conservatives talking about repealing or amending the Human Rights Act. Even going back so far as in the aftermath of the Aon Home Secretary decision and various other decisions at that time, you had Tony Blair, Charles Clarke, John Reid, the likes of those politicians saying, we need to tell the judges that they're doing this wrong. We need to tell the judges how to interpret the Human Rights Act in a way which is basically more favourable to us, the executive, which again, kind of misses the point. But anyway, so the thing that's bubbling under the surface here is that there is a clear body of political opinion which thinks that the Human Rights Act is too robust. It gives the judges too much power. It enables the courts to routinely interfere with decisions that have been taken by elected officials and the like. So there is a view that seems to suggest that we should be watering down our protections for human rights instead of either attempting to solidify them or maybe even, in fact, who dare say it, increasing them. Because one of the things that the Bill of Rights Commission pointed out was that there was also a concern about the frequency with which human rights are interfered with legislatively, never mind by either European or domestic judges. So I would say that my kind of defence of the Human Rights Act, or my support of it, is not necessarily related to how I think it's been given effect, but more to do with a concern over what might come to replace it. I have a range of difficulties with some of the ways in which the Human Rights Act has been interpreted. I mean, I've done a lot of work on Section 2, and I'm not quite sure that Section 2 has been interpreted and applied in the way in which Parliament, maybe, or the government probably intended it to. I'm not sure that the Section 19 procedure that ministers bring bills to Parliament fully rights audited, so that they're able to say, we are happy that this is compliant with the Convention rights. I'm not sure that has been anything more than a rubber stamp, really. I'm not sure that it's kind of promoted the kind of political dialogue that it was meant to. And so there are a number of kind of possible perceived weaknesses with the Act. Mm-hmm. But my concern would be that whatever replacement comes out of this process, if a replacement in fact does, it would not be as strong at protecting rights, and nor would it maybe balance legislative and judicial power in the quite neat way that the Human Rights Act seems to.
Yes, you mentioned the minority who have made a very big public statement. What have they said, and how have they come about their decision?
Well, they made a minority report in which they said that they did not think the case for a Bill of Rights had been made out, that they didn't think that now was the time to embark on an initiative such as this, and that their concern also was the concern that I spoke about a couple of moments ago, which was that there is a view amongst the majority, possibly the Conservative members, who knows, that whatever instrument emerges out of this process will either be weaker than the Human Rights Act currently is, or will sever ties with the European Convention on Human Rights.
What do you think the effects will be then of this result that's been achieved? What sort of effects do you think this will have on the future of the UK Constitution?
Big question.
It's a big question. I'm tempted to say none.
None.
I'm tempted to say none at all.
Why is that?
Well, partially because it's difficult to extract firm direction from the report of the Commission. Because even the majority were very clear that their point was that, or that they felt at least, there was a strong argument to look towards the establishment of a UK Bill of Rights. But then they also said anything that comes out of this, anything, should be the process. Should be a much kind of broader process of consultation. Should come from a much deeper kind of probing of the way in which a UK Bill of Rights might work than they were able to do. So my feeling is at the moment that nothing will happen in the short term, because the Commission were also relatively clear that the different constitutional kind of circumstances in England, Northern Ireland and Scotland in particular made immediate action, I think, basically impossible, because much is, I guess, at the moment at least, contingent on the ongoing debates around Scottish independence. So UK Bill of Rights is virtually meaningless.
If the UK ceased to exist as it is now.
Well, indeed.
Yeah.
But this is also a difficulty, because in the Commission's report, there was a clear sense that the political criticisms that have been levelled at the Human Rights Act by politicians in Westminster are not necessarily replicated in Scotland, Wales and Northern Ireland. Okay, so you have the sense coming through that the debate over a so-called United Kingdom Bill of Rights might actually be an English-only debate. You didn't get the impression that there was the weight of political opinion against the provisions of the Human Rights Act, or at least the provisions of the Human Rights Act as given effect in the devolution statutes, in Scotland, Wales and Northern Ireland as there seems to be in England. So, in the short term, I don't think anything will happen. In the long term, who's to say? I mean, the Commission, for some strange reason, or at least the majority at least, appeared to rule out a kind of a political counter-attack, a political initiative aimed at remedying these myths and half-truths that circulate surrounding the Human Rights Act itself. They appear to regard this as the Human Rights Act as a lost cause for some reason, and I'm not quite sure why. I mean, I would have thought in terms of effectiveness, efficiency in these times of austerity, that mounting a kind of a campaign in order to address some of these myths and half-truths might well be an awful lot cheaper than establishing a UK Bill of Rights. But, who am I to say?
Okay, thank you very much for speaking with us today.
Thank you.
For anyone who's interested in UK constitutional law, you could go for more updates at the UK Constitutional Law blog and also the UK Human Rights blog. And I believe we could follow progress on the book at
the recently established Twitter feed for the forthcoming textbook. It's Masterman and Murray.
At Masterman and Murray.
Mm-hmm.
Okay, thank you very much again. This has been Obiter, Durham University's Pro Bono Society podcast.